start. Today we will discuss legal position of directors. Now 5 points I have written. Directors as agents, directors as trustees, directors as managing partners, director as officers, and directors as employees and servants. Okay? So let us discuss with specific points. Number 1, directors as agents. Case law is there, Ferguson versus Wilson, 1866. In this case, the court has stated that company has no person. It can act only through directors. There must be somebody to run a company, somebody to take decisions for company. You know. So, representatives are board of directors. So they work like agents. Clear? Then directors as trustees. Okay. Before trust, I will tell you. Agency is the concept of contract of agency. Next year you would study the Indian Contract Act 1871 and 1872. In Indian Contract Act, different contracts are given like contract of guarantee, contract of indemnity in case of insurance, then contract of agency. In contract of agency, two parties are there, principal and agent. Agent gets salary or remuneration or incentive from principal and he has to work for his principal. He has to follow the commandments of principal, his boss, who appoints him. An agent is liable to follow the guidelines in exchange of that remuneration. Okay, that is contract of agency. Same concept is here. Directors gets their salary or remuneration, managerial remuneration, and in exchange of that, they work for the company. Directors' work means what? They take managerial decisions regarding raising of funds, investment of funds, purchasing properties, diversification of business of the company, and number of functions are provided for directors. Directors as trustees. Now trust is the concept of maintaining confidence between the parties. The Bombay Public Trust Act or Maharashtra Public Trust Act defines trust as an agreement between author or settler. Settler is a person. He is also called as author. Author means not book author. It's a concept of trust. Author or settler set aside some property in the hands of trustee or trust manager for the benefits of beneficiary. Exactly. In case of company, settler is what? Who is settler? Who appoints board of directors? Shareholders. Is that clear? Trustees are board of directors. They work as trust managers. Okay. And beneficiaries are again shareholders, employees. Because they get benefits in some or other way. Okay. Shareholders get dividends, employees get salaries. Okay. Customers get good quality of materials, whatever. So many stakeholders can be beneficiary in case of this. You know. So directors holds a fiduciary position which inculcates trust and confidence. When directors are appointed with election, shareholders vote for them. They provide confidence in them that he is a good person and he can work as a director very well. Our money, property will be safe. So directors are interested with money of the company, properties of the company, and IPRs. IPRs means intellectual property rights. There are intangible assets like patents, trademarks, designs, logos, copyrights. Is that clear? These are called as intellectual property rights, technical know-how, technology of production. All these are IPRs. So it is responsibility of directors to preserve these assets, monies and intangible assets of the company. So I hope it is understood. Directors as managing partners. So why managing partners? Number 1, they get managerial remuneration out of profits. And second thing, they hold substantial control on the affairs of the company through decision making. for achievement of objects and goals of the company. The main role of board of directors is to try to achieve the objects which are decided in your memorandum of association. You could recall clauses of memorandum. Second clause is objects clause. Name clause, objects clause, domicile clause, liability clause, association clause, capital clause, nomination clause. Out of this, objects clause is very important. Directors have to work for achievement of objectives of the company. Is that clear? Directors are officers. Only purpose of certain matters, directors are treated as officers. Not always. There are certain sections. For example, section 537, 538, 539, 540, 541, 542. For these sections, directors are treated as officers of the company. Yeah? Point number 5 is directors are employees and servants of the company. No, directors are not employees, neither employees nor servants of the company. They are representatives of the shareholders because they are appointed by annual general meeting of the shareholders. Employees are not appointed by annual general meeting, only directors. So they are not servants. Number 2, do not have claim on salaries. Like employees require every month salary. Directors cannot claim like this always. Third is, they can work as a director for more than one company. So multiple companies, up to ceiling limit of 20, one person can work as a director. So these are what the things which are showing the legal position of the directors as per the provisions of corporate law or the Indian Companies Act 1956. If any questions are there, you can ask. Now I am open to answer your questions. Any questions, any doubts? Thank you.
Thank you.